What is the future of statutory interpretation? What does the future hold for statutory interpretation? This question is becoming increasingly relevant as legal landscapes shift. Statutory interpretation is the process courts use to understand and apply laws. It is a fundamental skill in law school and a vital part of legal practice. One significant change on the horizon is the evolving relationship between courts and administrative agencies. Traditionally, courts often deferred to these agencies when interpreting ambiguous laws. However, recent Supreme Court decisions have started to limit this deference. Courts are now expected to apply standard rules of statutory interpretation more actively. This shift could lead to more varied outcomes across different jurisdictions. Another trend is the rise of textualism, a method that focuses on the ordinary meaning of statutory text at the time it was written. This approach has gained traction, especially with influential justices advocating for it. Textualism challenges the use of legislative history and emphasizes a fixed meaning. However, not all textualists agree on how strictly to interpret the text. Some allow for more flexibility by considering broader statutory context. Moreover, there is a growing perspective that challenges the traditional view of statutory interpretation as solely a judicial task. This new approach emphasizes how everyday people interact with laws. It considers the social and political contexts that shape legal interpretation. This could lead to richer discussions in legal scholarship and influence how judges approach cases. For law students, grasping these trends is essential. Courses on statutory interpretation are adapting to cover not only classical tools, but also the changing role of administrative law. Students will learn about the implications of recent Supreme Court rulings and how to prepare for cases in a world with less agency deference. Practical applications of this knowledge include analyzing how courts might interpret laws differently in this new environment. Students will also need to develop litigation strategies that account for these shifts. Understanding the legitimacy and limits of various interpretive methods will be crucial for future legal practitioners. In summary, the future of statutory interpretation is likely to be marked by reduced deference to administrative agencies, continued evolution of textualist methods, and increased focus on democratic participation in legal interpretation. Law students and academics must stay informed about these changes to navigate the evolving landscape of statutory interpretation effectively.